How late have you seen the judge yet?
No, I'm waiting to see the judge. No. Yep.
Mr. Isaac Noble El Amin, are you there?
Yes.
All right, we've been told, Mr. Sarch, you're here on that case. Is it my understanding that's just being left on for next week?
That's correct, Your Honor. We have the discovery.
All right.
Mr. Almain has been reporting to pretrial services and we'll be ready to go next week.
All right, so Mr. Ellerman, you should be all set today. We're just going to leave your case on for prelim next week. If you have any questions, please keep in contact with your attorney, Mr. Sartz, all right? All right.
Thank you, Your Honor.
All right, thank you.
Sitting here. You know, shit world, bro. You go to the bathroom, so I can sit properly. And it's going already. All right. Go. This is always real. Ready, bro. I have to use the bathroom.
So we're on the record in docket 23-01658. That's People of the State of Michigan versus Jessica Prawatsri-Chai. This is the time set for a probable cause conference in front of myself. Mr. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Ms. Prawatsri-Chai.
And this is the time set for a probable cause conference. Ms. McCray, how are we proceeding today?
Thank you, Your Honor. After speaking with brother counsel, the parties are going to leave this on for preliminary examination next week.
And is that your understanding, Mr. Abbott?
It is, Your Honor, and I should mention for the record that she is present by video.
All right. And ma'am, if you could pronounce your last name for us.
It's Prawatsri-Chai.
Prawatsri-Chai. Is that correct?
Yes.
All
sir.
right. Thank you. And you are Jessica Prawatsri-Chai?
Yes.
All right. Thanks. So it's my understanding this is left on for prelim on June 15th at 8:30. Is that correct, Ms. McCray?
Thank you, Your Honor. Yes.
All right. Anything else for the record in docket 23-01658, Ms. McCray?
No, thank you, Your Honor.
Mr. Abbott?
Your Honor, I've been in contact with Mr. Brodowitz, who's going to be handling the case. He's working on an offer.
Okay.
And as soon as he develops that, I will communicate it to our client.
All right. So the offer is open at this time, but negotiations are continuing.
Yes.
All right. So Ms. I'm going to mess that up. Prawatsri-Chai. If you have any questions, please keep in contact with your attorney, Mr. Abbott. We'll see you here on June 15th at 8:30. Okay, ma'am?
Okay. Thank you.
All right. Anything else, Mr. Abbott?
No, thank you.
All right. That's all for the record in 23-01658. You're all set, ma'am.
Okay. Thank you.
Judge, in reference to Judge Buchanan's docket, I believe Zion Owens is in the waiting room or in the Zoom in some form or fashion. So Mr. White and I are ready to go on record so long as he's present via Zoom.
All right. That is Mr. Owens. So with the person moniker Zion, I'm assuming you're Zion Owens. You'll have to unmute yourself.
Can you hear me?
So, okay, you are Zion Owens?
Yes.
All right. So we're on the record in docket 23-01670. That's people of the state of Michigan versus Zion Owens. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea McCray appearing on behalf of the people.
Good morning, Your Honor. Toby White here on behalf of Zion Owens. And as we've just heard from the bench, he's zooming in with us from home.
All right, sir, you are Zion Owens?
Correct.
All right. This is the time set for a probable cause conference in front of Judge Buchanan. Ms. McCray, how are we proceeding?
Thank you, Your Honor. After speaking with brother counsel, I believe the intention today is to waive the 21-day time period for the preliminary examination.
And is that your understanding, Mr. White?
It is, Your Honor. And I would add for the record that, actually, can we approach for a second?
Sure.
Sorry.
All right, so Mr. Owens, you understand you have a right to a preliminary examination within 21 days of your date of arraignment? Do you understand that, sir?
Yes.
Okay, and the preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence of the identity of the person who committed the crime and the crime in the file itself. Do you understand that, sir?
Yes.
And you, of course, are represented by Attorney Toby White. He would be present to cross-examine any witnesses or contest any charges brought against you in that preliminary examination. Do you understand that, sir?
Yes.
If you waive your right to a preliminary examination within 21 days, you'll be only waiving your right to a prelim within that time period. You would not be waiving your right to a preliminary examination in general. It is my understanding today you wish to waive your right to a preliminary examination within that 21-day period so that counsel has some time to adequately prepare a defense for you in this case. Do you understand that, sir?
Yes.
Is it your intention today and your wish to waive your right to a prelim within 21 days of your date of arraignment?
Yes.
Ms. McCray, are you also waiving the people's right to a prelim within 21 days?
Yes.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will set it for prelim on
June 29th at 2.
So, Mr. White, if we've got it June 29th at 2 o'clock, does that work with your trial schedule?
At 2 p.m.?
At 2 p.m.
That does work.
All right. All right. So, Mr. Owens, please keep in contact with.
Judge, pause that for a second.
Yep.
I don't know how flexible Judge Buchanan is, but if we could do it at 3 o'clock, I do have a hearing that starts at 1 that I know won't go.
May I make a
past 2.
suggestion?
Sure.
We set Baker for June 23rd at 1:30, so perhaps it might make sense to do it at 2 o'clock on June 23rd. That wasn't a date I was given.
Yeah, that we weren't given that
Sorry.
date. Yeah. But it is a perfect solution to a problem that we were not given that date.
Understood.
So, yeah, if we can kick it back an hour, I don't want to be late for Judge Buchanan.
It's not an option I was given.
That wasn't a slot we were given either. We were given specific slots. So do we have another slot date just to see if?
July 6th at 10.
July 6th at 10, does that work?
Oh, wait. She doesn't even, boy, she's picking the dates, isn't she?
We only have the slots we're given
At 10?
at 10.
Yeah.
Okay.
Let's go with it.
July 6th at 10 a.m. All right, so Mr. Owens, please keep in contact with your attorney, Mr. White. you are set for July 6th at 10 a.m. in front of Judge Buchanan. Okay, sir?
All right, got it.
All right. Anything else for the record? Docket 23011670, Ms. McCray.
No, thank you.
Mr. White?
Nothing further, thank you.
All
Your
right,
Honor.
thank you. That's all for the record in that file. Mr. Owens, thank you for your appearance. You're all set. Mr. Brodowitz, are you ready on anything? Or Mr. Stevens? I saw Mr. Stevens here first.
Do we have a review hearing on Meyer that was set for 8:30?
Yes.
We want to do that on the record, or can we talk to Your Honor about some possible solutions? Because we're a bit stumped.
You do not order the defendant on Polycom. This was for the attorneys to try to figure out some.
All right.
Some movement.
Let me put that. Is anything ready to go?
Are you ready to go?
Yes.
Okay, we can do the.
Let's do that and then let's go ahead and meet on that.
Okay.
So Mr. Milks, you're here on Werwin. Thank you. All right. So we're on the record on dockets 22035572 and 22-03573. That's People of the State of Michigan versus David Werwin. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milton after Mr. Werwin, who is present and standing to my right at this time.
And sir, you are David Werwin?
I am.
All right, thank you. This is the time set for a plea today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. After speaking with defense counsel, I believe we have come to an agreement in this, and that would be for the defendant to plea to one count of domestic violence in, that would be count 3 in file 22-03572 FY with 76948 if eligible, and an agreement for no upfront jail. And then with that, the people would seek to dismiss counts 1 and 2 in that file. And the people would also seek to dismiss both counts 1 and 2 in file 22-03573.
All right, so let me make sure I have that right in the record. Plea to count 3, plea discharge, Killebrew 769-4A, and a Killebrew to no upfront jail. Is that correct?
Yes, Your Honor.
All right, and with a plea to count 3, dismiss counts 1 and 2. 1 and 2. And then in file 22-03573, dismiss all counts in that file.
Yes, Your Honor.
All right. Mr. Milks, that's your understanding of the plea agreement?
Yes, Your Honor. That is a complete and accurate statement of the plea agreement.
All right. May I inquire of your client of his advice of misdemeanor rights?
Yes, sir. Thank you.
And did you have him sign anything?
Yes, Your Honor. I believe, okay.
Thanks. All right. I thought I saw him do that. I wasn't sure. All right. So you understand you have the right to a preliminary exam. You have a right to a jury trial on this misdemeanor charge. This is the agreement. And my understanding is you're pleading to count 3, which is a domestic assault. It's punishable by 93 days and or $500. Do you understand that? Is that a yes?
Yes.
That's what it's punishable by. All right. It's my understanding is part of the Killebrew agreement. You'll be pleading to that, and there's no upfront jail, and there's a Killebrew to 769-4A status that you probably talked to with your attorney about that. Is that correct? All right. If I choose not to go that route, you have the choice to withdraw your plea. Do you understand that? Okay, so that just so we're clear on the rules, it is punishable by 93 days and or $500. However, there's a Killebrew agreement. If I don't follow that Killebrew agreement, you can withdraw your plea. You understand that? All right. So you've given me an advice of rights form on your misdemeanor rights, and you've signed it, and that's this document here. Is that correct? All right. So, and you understand all the advice of rights that have gone through here on this document. Is that correct? I'll just cover 3 with you. All right. You understand you have a right to trial by jury in this case. You have the right to counsel. You, of course, are represented by Mr. Milks today. He would be present to cross-examine any witness or contest any charges brought to you at trial. Do you understand that? All right. And you have the right to remain silent. Anything you say and use can't be held against you in a courtroom or a trial. Do you understand that? All right.
You think you're speaking up?
Yeah.
No.
All right. With those 3 rights and this advice of rights plea, you have an understanding of all your rights. You won't be getting a trial today. You'll be pleading guilty. Do you understand that? Okay. So I'm going to bring your attention. So raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. I'm going to bring your attention back to the date and time, which is November 28, 2022, at the offense location of Dexter Drive in the city of Lansing. Were you on Dexter Drive in the city of Lansing on November 28, 2022? Yes. And is Jane Jakeway a resident or former resident of your household or someone with whom you had a dating relationship?
Yes.
Okay, which one is that?
She lives there.
Okay, she lives there. Did you also live there?
Yes.
Okay. And why don't you tell me what you did to be guilty of assault and or assault and battery or offensive touching of Miss Jakeway?
I grabbed her around the shoulders and slapped the top of her head with the flat of my fingers.
All right, and that was against her wishes?
Yes.
Okay. And you did not do so in self-defense?
No, this was horseplay that got out of hand.
All right. Anything towards the factual basis of Mr. Brodowitz?
Nothing from the people, Your Honor.
All right, Mr. Milks?
Just for some clarification,
Okay.
Sir, you're currently on medications today, is that right? Yes. Okay, and these are the right prescription pills that you're on and the right dose and right level, is that right? At the time of this offense, were you on medications at the time? Not for that. Okay. Did you understand or remember and recall everything that was going on at that time, though? Yeah, I think so.
All right.
Thank you, Your Honor.
Thank you. So I find that the factual basis to be knowing, voluntarily, and accurately made concerning count 3. So counts pursuant to the agreement, counts 1 and 2 are dismissed, and I'll sign that nollie-pros. I don't know about so that would be on 7-3. Counts 1 and 2 are dismissed on this file, which is 7-2 as part of the plea agreement. We're going to refer to probation. So we'll refer to probation. What they'll do is they'll provide a report for me, and you answer all their questions. Provide a report for me, and then we'll come back and see what options are available to us at sentencing. Okay. All right. So refer to probation. You can go there today. Probably a good idea to walk down there today and get the process started. Sentencing date?
July 20th at 8:30, if that works for Mr.
Okay, July 20th at 8:30, and you may want to check your calendar, Mr. Milks.
Yes, that should work. Thank you.
Okay. So we are set for sentencing on July 20th at 8:30. At that time, a report will be made, and we'll see what options are available for us in regards to this file. Okay, sir? All right. Anything else for the record in either docket, 22-03572 or 573, Mr. Brodowitz?
Nothing from the people.
Mr. Milks?
No, thank you, sir.
All right, we'll see you on July 20th at 8:30. All right, sir? You're all set. Okay, thank you.
He does have the notice of referral in his hand. Sorry.
All right.
Miller.
Oh, Mr. Brodowitz, you'll have to sign the nominee. There you go.
Oh.
Sorry. Give me 1 second, get your file.
All right, thank you.
I'm just asking if that's okay, because you guys are next. I'm looking to appeal to you.
All right, here's Mr. Warewin.
Far too young.
All right,
I like your socks, they match your top.
and then who is that conflict counsel? All right,
Yeah.
so Mr. Stevens, are you ready on Conley, or did you want to?
Okay,
Do you have other matters that you would like to address, Mr.
Your Honor, I was seeking permission from the great Mr. Stevens, if it would be okay if I could butt in line, because we've got two PCCs on that we're just leaving on for prelim.
Look, I'm just here to take whatever you want to put in front of me, okay? So what would you like to call next?
Go ahead.
Okay,
Your Honor, I think we've got whoever you want to call.
Yeah, we can call Jordan Yu, Your Honor, and that's from Judge Buchanan's docket.
all right, Mr. Yu.
Yes, sir.
All right. So, Mr. Yu, we're going to call your case, your probable cause conference case. This is on the record in docket 23-01659. That is people of the state of Michigan versus Jordan Yu. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea McCray appearing on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Yu, who is present with us via Zoom at this time.
And sir, you are Jordan Yu?
Yes, sir.
All right. And you can hear me all right, Mr. Yu?
Yes, sir.
All right. This is the time set for a probable cause conference in front of Judge Buchanan. Ms. McCray, how are we proceeding?
Thank you, Your Honor. The people are asking for a good cause adjournment to move the preliminary examination due to the fact that one of my officers I would need to testify for the preliminary exam, Julian Colby, will be on vacation for the next 2 weeks, and she is not available until the last week of June. And so I am requesting that this court reschedule the preliminary examination until the last week of June, either the 29th or 30th, if my judge has provided appropriate slots, I should say.
All right, Mr. Milks, any response?
Thank you, Your Honor. Your Honor, I have not had a chance to speak with Mr. Yu yet. We did not have a good working phone number for him. He's relayed that to me. We've been able to contact a little bit through email. So it's hard for me to say whether or not we object. I think in general, we would like to leave it on for next week for the preliminary examination, so that he has his prelim within the next 21 days.
All right, and Mr. Yu, that's a correct statement by Mr. Milks that you have not had an opportunity to go over any of this current situation with your attorney?
Yes, sir. That is correct.
All right, thank you. I find somebody being on vacation is good cause to adjourn this. So I will adjourn for good cause. So, Mr. Yu, you're not waiving any rights today. The court on its own is at the request of the prosecutor is adjourning the matter for good cause because we have a witness on vacation. And we'll get a new date. June 29th at 2 o'clock. Mr. Milks, you may want to check your schedule. Ms. McCray, I'm assuming you'll be in front of Judge Buchanan at the time.
Yes, we will be ready.
Karen, I think that will work. June 20th, that's it.
June 29th.
29th.
Yeah.
Yes, Your Honor, that should work.
All right.
Thank you.
So we'll reset this for June 29th at 2 o'clock. Mr. Yu, you've not waived any rights today. You still have all your 21 day, you have your timeline intact, and you also have your right to prelim. This is a good cause adjournment because a witness is unavailable. All right, sir?
Okay.
All right. So please keep in contact with your attorney, Mr. Milks. And Judge, you'll be in front of Judge Buchanan on June 29th at 2 o'clock. All right, sir?
All right. Thank you.
All right. Anything else for the record? Docket 23-01659. Ms. McCray.
No, thank you.
Mr. Milks?
No, thanks, sir.
You're all set. Mr. Yu, thank you for your appearance today.
Have a good day.
Now, Mr. Stevens, what are we going on?
done.
Good else is you.
No, get it done.
Apologies, Your Honor.
Right.
Here we are again. I think Miss Alanese is on. Is she on the Zoom from the jail from the poly?
Right. So, ma'am, are you Alexis Alanese?
Yes, sir.
All right. I'm going to assume we're going on Miss Alanese.
Please, Your Honor.
All right. So we're on the record in docket 23-01662. That's people of the state of Michigan versus Alexia Alanese. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Ms. Alanese, who is present with us via Zoom at this time. She is in Ingham County Jail.
And ma'am, you are Alexia Alanese?
Yes, sir.
Okay, and you can hear me all right, Miss Alanese?
Clear.
All right, thank you. This is the time set for a probable cause conference in front of Judge Buchanan. Ms. McCray, how are we proceeding?
Thank you, Your Honor. At this time, we are leaving the matter on for preliminary examination next week. I will note that we have made an offer to Mr. Milks of an added count 2 of home invasion in the 3rd degree. We would dismiss the original count 1. There is no sentence agreement, but negotiations can continue in circuit court if brother counsel so chooses.
And Mr. Milks, is that a correct statement?
Your Honor, that is a correct statement. I would just quickly note, we were very recently appointed to Ms. Alanese's case, so I still need the opportunity to speak with her. I've spoken with her family members, but there was also no indication from my office that she was incarcerated. So, yeah, so this is where we are.
All right. So, Ms. Alanese, please keep in contact with your attorney, Mr. Milks. Your preliminary examination has been left on in front of Judge Buchanan for June 15, 2023 at 10 o'clock. All right, ma'am?
Okay.
All right. Anything else for the record? Docket 23-01662, Ms. McCray.
No, thank you.
Mr. Milks?
No, not in this matter, Your Honor.
All right, thank you. Ms. Alanese, you're all set.
Thank you.
I know.
Your Honor, I was hoping I could approach and just talk to you for a few hours regarding Ted Lasso's final.
Man, who's over there?
Sir, you are Aaron Conley?
Yes, sir.
All right. And you can hear me all right, Mr. Conley?
Yes, sir.
All right. This is the time set for a probable cause conference in front of myself. Mr. Stevens, how are we proceeding?
Your Honor, at this point, I'll defer to Mr. Johnson on this. I spoke to him briefly. Before I walked over, I looked in our file. We had not received an appearance, so I actually didn't know who I would be speaking to until I arrived at court today. So with that, I'll defer to Mr. Johnson there. Depending on how this sort of goes, I have some additional comments regarding co-defendants, but
all right,
I'll wait on that for a minute.
So, Mr. Johnson, it's my understanding you were that the previous counsel, we adjourned for good cause and the previous counsel withdrew. Is that correct, Mr. Carter?
Yes, sir.
All right. And so how are we proceeding today on this probable cause conference?
We're prepared to continue to examine the 15th. We'd like to address a restriction the court has placed upon my client.
Okay. So at this time, the request for the defendant is to continue this to preliminary examination on next week. That would be June 15th at 8:30.
As we anticipate having all discovery by then, Your Honor, being prepared to go.
All right, Mr. Stevens?
I have nothing to say regarding that, other than I would inform the court that there may be a slight wrinkle in it, not from the people's perspective, but from the public defender's perspective. As the court is aware, Mr. Johnson and previously Mr. Carter were conflict counsel for Mr. Conley. The public defender's office also represents a female, Jessica, and I'm not even going to take a stab at her last name. It was a pre-exam conference this morning. She was represented by Mr. Abbott.
All right, is that Miss Prawatz?
Yep.
Chai?
Yes.
Okay.
Mr. Abbott is unclear at this moment whether he can remain on as counsel.
Okay.
Due to potential conflict. And given this case, Mr. Conley's present case, his additional case, and the co-defendant, Mr. Ben Conley and Jessica, that could pose a potential wrinkle if Mr. Abbott cannot represent her due to conflict. So at this point, it is an unknown. I know Mr. Abbott left it on for exam next week, and we're going to proceed as if it's going to be an exam next
All
week,
right.
but he's going to investigate the conflict and reach out.
All right, so I think I understand the nature of this. And so what we'll do is we'll just leave this on for prelim with the understanding that whatever happens, happens, and there may be a request by the parties at that time. So but at the defendant's request, this is left on, and my understanding is that the people are also requesting this be left on for June 15th at 8:30. Is that right, sir?
Yes, Sean.
Okay, so we'll leave the prelim on for June 15th at 8:30. All right, Mr. Conley, you understand this is left on for prelim today, for next week on June 15th at 8:30. Please keep in contact with your attorney, Mr. Johnson, and he can answer any questions you have. Right now, we're set for prelim on June 15th at 8:30. Okay, Mr. Conley?
Sir.
All right. Anything else for the record in docket 23-01606 or 23-01236, Mr. Stevens?
Nothing from the people.
Mr. Johnson.
Yes, sir. Your Honor, it's my understanding, I'm speaking to my client, that he's been in the hole for 2 weeks. There's some restrictions on his telephone use. We'd ask the court to to lift those restrictions. It's my client's position that he has not received any tickets or warnings since he's been in the county jail. If there is concern of him contacting a particular person, I don't know what system that the Ingham County Jail uses, but I know in Jackson County that there's the ability to block certain phone numbers. So there will be less restrictive means to ensure any no contact orders. But since I have very little knowledge of the basis of violation, I can't really speak to that. But we just asked the court to consider lifting the restrictions, especially if it's been 2 weeks and he's been in the hole for 2 weeks.
All right. I have on May 26th, I revoked privileges, any contact while at Ingham County Jail. I'm assuming it was based on the request of the prosecutor's office, Mr. Stevens.
That was correct, Your Honor. At that time, Mr. Conley was only before this court on the pre-exam conference for his first case, which was a co-defendant file with Ben Conley. And this was the unlawful imprisonment case. I indicated to the court that as I was walking over and later that same day, Mr. Aaron Conley was going to be arraigned on a new felony charge or a new felony file of intimidating witnesses, in which he was a co-defendant with Jessica, last name I'm not going to take a stab at, we've already referenced, and another individual, Jonathan Beck. Furthermore, and Mr. Conley was in fact arraigned on that file, and he's here today for the pre-exam conference or probable cause conference for that case. In addition to that, I indicated to the court that as I was walking over for the initial pre-exam conference, I was contacted by Detective Sergeant with the Ingham County Sheriff's Office that they had intercepted additional telephone and video communications between Mr. Conley and other individuals that seemingly and probably not so subtly referenced witnesses in the unlawful imprisonment case. And upon my motion And in light of those facts and in light of the new case, specifically witness intimidation, this court granted my request to restrict access. I can certainly go into additional facts I had said before, and I'll say it again today. It wasn't my intent then, nor my intent now to try the facts of that before this court. And certainly to Mr. Johnson's side, it would be almost unfair for me to do that because Mr. Johnson, as he indicated a second ago, doesn't know the full nature, doesn't even have discovery on it. And I think that would be an unfair disadvantage for him. But based on that, and there really hasn't been a change in circumstance, I'd ask that those restrictions remain in place. I think your ultimate order, Judge, was upon review or when the evidence is presented, that motion can be brought back up again.
All right, Mr. Johnson, any response to Mr. Stevens' comments?
Yeah, basically, so
Can I speak, Your Honor?
he mentioned witnesses on a phone call. I understand he doesn't go into the facts, but I haven't heard a threat or a bribe or any type of coercion to justify saying that you can't talk to anybody. It's one thing for the court to say, it'd be typical for the court to say, you can't talk to co-defendants, you can't talk to witnesses. But for him to not be able to talk to anybody, and based on, we haven't even heard a threat yet at this point.
All right, thank you. It's 1 week till the preliminary examination. I'll revisit this. The 2301-606 file is witness intimidation. So I do think out of an abundance of caution that the defendant's privileges will remain intact without contact till the June 15th date, and then we can revisit this issue at that time. But for the next week, the defendant will not have any contact while at the Ingham County Jail with any witnesses until we hear the review of the facts of the case. So the motion is denied. Anything else for the record on either case, 2301-236 or 2301-606, Mr. Stevens?
Again, nothing from the people.
Mr. Johnson?
No, Your Honor.
All right, thank you. That's all for the record in that file. Mr. Conley, we'll see you next week.
So I can't say nothing, Your Honor? Sir?
No, you have a lawyer, so you shouldn't.
I'm gonna come over to the jail.
I just want to state that on the 26th, Your Honor, with David Carter withdrew from my case, you adjourned my preliminary examination, even though on the record I stated I wanted my preliminary examination that I would represent myself, but you felt that I needed proper representation. But then you allowed a prosecutor to purposely commit prosecutorial misconduct by arguing issues that I didn't have a lawyer to represent me on. So I don't feel that if you felt I needed proper representation for one, I should have needed proper representation for the other one, Your Honor. Not only have you restricted my contacts, Your Honor, they have me in a hole based on the email you sent. On May 26th, when I came back to the jail, they already had my property packed up from my cell and placed in a segregation cell, Your Honor. Off of your word, all I'm asking, sir, I understand the public of the safety is the most important, so I understand the restrictions state, but can you please, Your Honor, I can't prepare for this case. They won't allow me law library, commissary. They won't allow me nothing. I am in isolation underneath the jail, Your Honor. Lights on all day, flat clothes. I'm around the mentally insane that beat, scream, kick. There's no sleeping. Like, Your Honor, I cannot prepare for my case under these circumstances. All I'm asking, okay, keep the restrictions, sir. Please let me out the hole. Ask them.
All right, Mr. Conley, you can bring any redresses to the court's attention through your attorney, Mr. Johnson. That's all for the record in both these files.
Yes,
Well, I'd ask court to consider just taking him out of segregation with no phone privileges.
He is where he's going to be until we have the preliminary examination, sir.
Yes, sir, Your Honor.
Okay.
Mr. Conley, I'm gonna come see you at the jail probably tomorrow.
Thank you, sir.
Yep.
Let's go on. So did you want to discuss Mr. Meir?
Sure.
All right. And then we can go on the rest of the files.
Sure thing is not.
Ms. Martinez, how are you?
Great.
Mr. Goodrich?
Yes.
My understanding is we are taking a plea on your client, Mr. Short.
Yes.
Are we?
I have plea paperwork if you need it. I know he doesn't do it, but my judge does, and I don't want him to yell at.
Okay, I just need to finish my question now, please. Sorry, it's okay. Mr. Goodrich, is this gonna go before Judge Buchanan for sentencing or Judge Flores?
Judge Buchanan.
Okay, thank you.
I think Luke, we're
Yep,
gonna have to
I
put a
figured that
record
much.
we're waiving being sentenced by the plea judge.
Yes.
No skill.
Huh?
No skill.
Yes.
Can you guys hear me?
Mr. Eisenman, your sound is working.
Can you hear me now, Your Honor?
Yeah, we can hear you, Mr. Eisenman. The judge will call your case here in a few minutes.
Okay. Huh. Mhm.
From the Ingham County Jail, Polycom, what's your name, sir?
Shane Cox.
All right, thank you, Mr. Cox. People handle certain types of cases. Sir, that just joined from Eaton County, are you Kelly Witt?
Yes, sir.
All right, thank you, Mr. Witt. I'm gonna put you into a breakout room with your attorneys.
They called me first. I'll be back.
Thing to
On the
that.
iPhone, what's your name, sir?
We try, and it goes like.
Michael Williams.
One more time.
Michael Williams?
I'm going to need that.
Yes.
All right, thank you, sir.
Okay, my back down.
Mr. Meyer.
Yeah.
She already knows.
And Miss Witt,
Yeah, he's Mr.
Mr. Witt.
She. He's well aware of my mental health.
Mr. Cox has been in the videos.
We all have different ones.
Who's that?
One of ours that's in custody.
Okay.
Mr. Goodrich's client, I'm not sure Mr. Goodrich has returned
He
yet.
was here.
He had to go take care of some, I'm not sure.
Just got.
Well, we're all going now, right? All right. So we are on the record in docket 21-02458. That is people of the state of Michigan versus Ahmed Meyer or Mir. Will the parties please introduce themselves for the record?
Andrew Stevens on behalf of the people.
Deborah Martinez on behalf of Mr. Meyer, who is not present today, but I'm waiving any appearance that may be necessary for purposes of this discussion.
All right. This is the time set for forensics review. After discussion with counsel, it's come to the attention that Mr. Meyer is still awaiting the evaluation, the report for the evaluation for the criminal evaluation. Is that my understanding, Mr. Stevens?
So he has been deemed incompetent by this court in a signed order. And it is at least the party's understanding, based on the opinions from the Center of Forensic Psychiatry, that competency can be restored upon proper treatment. Where he presently stands, however, is he has not been received by nor treated by the Center of Forensic Psychiatry. Instead, he is currently being held at the Ingham County Jail, not receiving any sort of treatment to restore competency. I don't want to put too many words in the mouth of Ms. Martinez, because I know she has spoken with CFP more than I have, but in essence, she is being told on behalf of her client that he's on the list, but there is no certain term as to when he will be transported from the jail to the Center of Forensic Psychiatry and when that treatment will begin, effectively leaving this case in a sort of stalemate holding pattern. Hope that summarized it, and then I'll defer to Ms. Martinez if I didn't say anything correctly.
All right, Ms. Martinez.
Your Honor, that is correct. Mr. Meyer is currently awaiting treatment and has been in the Ingham County Jail for several months now, even as I pointed out in discussions. Even if he pled straight up to these charges, he would be well past his guidelines already due to his lack of criminal history. Just this morning, we received another message from the Center for Forensic Psychiatry, which we have diligently been checking in with each month since this court signed the order for treatment. And it says, "Thank you for your inquiry. Due to limited bed resources and increased demand throughout our hospital system, there are extended delays in our admissions process. As a result, we anticipate that it will be several additional more months before Mr. Meyer will be admitted for competency restoration treatment." So not only are they saying several additional months, they're not able to tell us where he is on any list, how many months that might be, or any alternatives for treatment for Mr. Meyer in the meantime.
All right. So the court needs to move the case, and the parties can't move the case because of the forensic review. I mean, that's essentially what we have. We also have Mr. Meyer incarcerated for an indefinite period of time because he can't be seen, and of course he can't plead to anything because he has to be seen for forensic review before he pleads to anything or before anybody goes forward on this case. So what we're going to do after discussion with counsel is we are going to set this for 30-day forensic review, for a forensic review in 30 days, with the understanding, and I posed this to counsel, especially Mr. Stevens, that if we don't have an answer and we don't have a report within the 30 days, or at least an answer or a time frame, then I'm going to show cause community mental health. I've done it before. I'll do it again. We can have it's actually the forensic center. I'll show cause the forensic center to come in and to explain why this individual who's been incarcerated for months at a time does not have a time frame, and we can't go forward without their assistance. None of us can go forward without their assistance. So I'll get a date out, a 30-day out for. We also discussed a plan B in this matter, and Ms. Martinez is going to be looking into a plan B. I don't want to indicate what that plan B is on the record because I want to understand this isn't the first time that this has happened. So we have to address this issue that we can't go forward with an individual incarcerated when they have not been evaluated, and we have no time frame for evaluation. So we'll set it for forensic review 30 days out.
July 7th.
So it'll be July 7th at 8:30. And if we don't have an answer and we've simply adjourned 30 days, Mr. Stevens, you can let the forensic center that the court will order a show cause as to why we don't have a time frame. I think I've said that on the record, and you can share with them that information that they're going to be accountable to why we can't proceed in this matter. Anything else for the record in docket 21-02458, Mr. Stevens?
Nothing from the people. Thank you.
Ms. Martinez?
No, thank you.
Okay, you're all set. Thank you for your appearance today. I signed it. I think I signed it. I do. There you go. So we're on the record in docket 23-01645. That is People of the State of Michigan versus Joshua Eisenman. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Eisenman. I am standing in for Attorney of Record Edward Hess, who is in trial today.
All right, thank you. And Mr. Eisenman, you'll have to unmute yourself. You are Joshua Eisenman?
Hello. Yes, Your Honor.
All right. And you can hear me all right, Mr. Eisenman?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer for the defendant to plead to count 2 domestic violence. With that, the people would dismiss count 1 and would also, I guess, I'm not sure if it would be withdraw or dismiss the second offense notice. So it would be just a plea to straight up count 2 domestic violence. However, after conversations with defense, I believe we're going to leave this on for preliminary exams.
All right, Mr. Milks, that's your understanding. The offer's been made and this will be left on for preliminary examination.
Your Honor, that is my understanding. Speaking with Mr. Hess, and obviously we just received the plea offer today. I believe there's also a pending probation violation. So I know our office has been in contact with Mr. Eisenman. I believe Mr. Hess tried to reach out to him, but they've not been able to connect yet. But I believe Mr. Eisenman has been in contact with Lawrence Sutter from our office.
All right, thank you. So, Mr. Eisenman, we're at this PCC hearing. We're leaving your preliminary examination left on. It'll be live in person on June 15th at 8:30. Okay, sir?
Yes, Your Honor.
All right. Anything else for the record? Docket 23-01645, Mr. Brodowitz.
Nothing from the people, Your
Mr.
Honor.
Milks?
Nothing from the defense. Thank you, sir.
All right. And so please keep, it'll be Mr. Hess, correct?
Yes, sir.
So please keep in contact with Mr. Hess concerning the offer, and we'll see you on June 15th next week at 8:30. Okay, sir?
Yes, Your Honor.
All right. Thank you. That's all for the record in that file.
And then.
Thank you.
All right, Mr. Owens, we're just waiting on, and anybody who's waiting on Mr. Goodrich, he's in another prelim right now, or he's in another courtroom. And so we'll call your cases once he comes back, okay?
Okay.
All right, thank you. All right, Ms. Polda and Mr. Witt, we're ready on your case. Mr. Cornish, all right. We're on the record in docket 20-02393 and 23-01533. This people of the state of Michigan versus Kelly Witt. Will the parties please introduce themselves for the record?
Thank you. Sarah pulled on behalf of the people.
Good morning, Your Honor. May it please the court. Deputy Chief Public Defender Steve Cornish on behalf of Mr. Witt, who's appearing from the jail on Zoom. Mr. Witt, please say good morning, introduce yourself and spell your last name.
Good morning, Kelly Witt, WHITT.
Thank you. And then Mr. Brodowitz, you're here on the second file, is that correct?
Yes, Your Honor. Jeff Rodowitz on behalf of the people on file 20-02393.
All right. And this is the time set for a probable cause conference. Mr. Witt, you can hear me all right in the jail?
Sir.
All right, thank you. This is the time set for PCC. Ms. Polda, how are we proceeding today on 3-3?
Thank you. After speaking with defense counsel in this matter, it seems that it's prudent for both parties to delve more deeply into the discovery of this matter. I know that the public defender's office has received a lot of discovery. Seems we are still waiting an autopsy report in this case as well. So I believe that the defense will be requesting an adjournment.
All right. And so as to file 23-01533, Mr. Cornish, what is your understanding today?
That's correct, Your Honor. We're diligently working our way through that. There is a substantial amount, as you would expect in this type of a case. I've spoken to Mr. Witt this morning. He is in agreement with waiving that 21 days. We'd be asking just to adjourn that out to give us some time. I would suspect approximately a month from the day would be satisfactory, but as the court has time.
All right. So that's as to docket 23. Let's take that as to 23-01533. Mr. Witt, you understand, counsel, may I inquire of your client of his 21-day waiver on that file?
Of course, Your Honor. Yes.
All right. So, Mr. Witt, you understand you have a right to a preliminary examination within 21 days of the date of arraignment, and we have set that for prelim for next week. At that preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You, of course, were represented by attorney Stephen Cornish, and he would be present to cross-examine any witnesses brought by the state or contest any charges brought against you at preliminary examination. It's my understanding today that in order to get for full discovery, so Mr. Cornish can zealously advocate on your behalf, it's your intent to waive your right to a preliminary examination within that 21-day period. You wouldn't be waiving your right to a prelim in general, only be waiving your right to a prelim within 21 days so that all the information gets to Mr. Cornish and Ms. Polda has all the information concerning this case. Is it your intent today to waive your right to a preliminary examination within 21 days? Is that a yes, sir?
Yes.
Okay. And Ms. Polda, do the people waive their right to a prelim within 21 days?
Yes, thank you.
All right. With that understanding, the waiver of the 21-day rule, only waiving the 21-day rule, not a right to preliminary examination, is found to be knowing, voluntarily, and accurately made. And we will reset the prelim on 23-01533. So you're thinking, Mr. Cornish and Ms. Polda, in order for full discovery, we're thinking 21 to 28 days?
That sounds about right.
Is that Mr. Cornish? Does that sound about right?
Yes, Your Honor.
All right. So 3 to 4.
July 6th at 8:30?
Okay, so July 6th at 8:30. You might want to check your trial schedule for that.
It works for the defense, Your Honor. Ms. Polda?
All right.
Yes, it works for me too. Thank you.
All right. So we'll reset this for July 6th at 8:30 for preliminary examination. Anything else in regards to this file, 23-01533, Ms. Polda?
Yes, I found out after this case was charged that the defendant's name, his first name, is misspelled on the complaint and in the court records. It's missing the second E, so it would be spelled Kelley. We'll be making a motion to correct the spelling of his name, and we will file an amended complaint in the district court when we come back on the preliminary examination date.
All right, thank you. I've made the oral amendment.
We can just.
Okay, and if it, okay, so we've made the oral amendment. I've made it on the complaint. We could make it in the computer, and then we can await the paperwork to catch up. Mr. Cornish, any objection to adding the second E on Mr. Witt's name?
I have no objection, Your Honor. If Ms. Polda hadn't brought that up, it was going to be my suggestion the court fix that. So I appreciate her bringing that up.
All right. Anything else for the record in docket 23-01533, Ms. Polda?
No, thank you.
Mr. Cornish?
Nothing from the defense. Thank you, Your Honor.
All right, we're all set on that file. And then we're on the record in docket 20-02393. And Mr. Brodowitz, how are we proceeding on the 9-3 file?
Yes, Your Honor. After I spoke with Public Defender Sarts, I'm not sure if he's still on this file or not, but I believe this file as well, the defendant will be waiving his 21-day timeline in that matter. So with that, the defense.
All right, Mr. Cornish, what's your understanding as how we're proceeding on 20-02393?
That's correct, Your Honor. There was an offer extended. We'd like some time to sit down and go over the discovery with our client, talk to him. And I just think it's best practices to keep the cases together. So we're doing it all at one time. So I would ask the court to move it to that date. And if we decide that he would like to accept their offer, we can move that forward sooner and let the court know that.
All right, so Mr. Cornish may inquire of your client of his waiver of his 21-day rule. And then will just set this for the same preliminary time as the last case.
Very good, Your Honor.
Thank you. Mr. Witt, you understand you have a right to a preliminary examination in this file, 21 days of your date of arraignment. A preliminary examination is, of course, a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You are represented by Jacob Sarts from the Public Defender's Office in this file. Mr. Cornish is standing in for Mr. Sarts today, and it's my understanding you wish to waive your right to a preliminary examination within 21 days. You won't be waiving your right to a prelim in general, just within that 21-day period, so that Mr. Sarts can take the offer, consider the offer, and share the offer with you in regards to the other file, and you can talk about it. Is it your intent today to waive your right to a prelim within 21 days on this file?
Yes, sir.
All right. I find and you do waive your right to a prelim within 21 days. Is that correct, sir?
Yes.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and we will set this prelim for the same date as the other prelim, which is set July 6th at 8:30. Anything else for the record? Docket 20-02393, Mr. Brodowitz.
Nothing from the people.
Mr. Cornish?
Nothing from the defense. Thank you, Your Honor.
All right. Mr. Witt, you're all set. Please keep in contact with your attorneys, Mr. Cornish and Mr. Sarts, and we'll see you on July 6th at 8:30. Okay, sir? All right. We're all set. Thank you for your appearance today.
Thank you, Judge.
Thank you, sir.
And then this is Mr. Perry Johnson.
Yes, sir.
All right. All right, we're on the record in docket 22-00387. That is People of the State of Michigan versus Jeremiah Perry Johnson. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Perry Johnson, who is present and seated to my right at this time.
And sir, you are Jeremiah Perry Johnson?
Yes, sir.
Okay, this is the time set for a probation violation hearing. I don't know if I called it without seeing if the parties had spoken or anything along those lines. Mr. Brodowitz, if you need some time to speak to Mr. Milks, take your time, but how are we proceeding today?
Just briefly, a couple of minutes. to
Okay,
speak.
all right, yeah. So I'll give Mr. Milks and Mr. Brodowitz a chance to talk about the case. I saw Mr. Goodrich left and we had him, right? We had Mr. Goodrich, we had him.
Yeah, we had it for a second.
want to dismiss our position.
Mr. Owens, Mr. Owens, are you there?
No, that's not.
Oh, this is this case? Oh, Lord. No, you cannot.
Mr. Owens, are you there?
Okay.
Philip Owens?
So what is the violation?
There you are. I'm gonna put you in a breakout room with your attorney, Mr. Goodrich, all right?
Okay.
All right. So you should get a prompt to go, what room?
Okay. Do you want me to?
You'll get a prompt to go to room 2.
Okay.
Yeah, they're actually really.
All right, Mr. Zappin, we can call your case. So we're on the record in docket 22-03199. That's Sandhurst Apartments versus Josephine Blue. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Michael Zappin, P68107 on behalf of the plaintiff.
All right, and this the time is set for I have a motion for eviction. I have that there was previously the default was granted on this on February 27, 2023, as the defendant failed to appear, and the January 4th, 2023. Is there a Josephine Blue in the courtroom? Is there a Joseph? I do not see a Josephine Blue in the Zoom courtroom, and I don't see a Josephine Blue in the physical courtroom. Mr. Zappin, it would appear that Ms. Blue has failed to appear for your motion. How would you like to proceed?
Yeah, we're just requesting the motion be entered for an order of eviction. The plaintiff has been trying to work with the tenant for some time now to no avail. So we're at that point where we'd like to send in the paperwork for an eviction order.
All right. I have on January 4th, we met, the defendant failed to appear. We set it for formal hearing. On February 27th, the defendant failed to appear, and the default was granted. So you'll follow up with any orders for the court to sign in regards to your motion?
Yes, Your Honor.
Parents killing their children, children killing their parents.
Yes, Your Honor. We'll do that today.
All right. So I will orally grant the motion at this time based on a continued fail to appear by Ms. Blue. As indicated previously, this was scheduled for 10 o'clock. It's now 10:33. And I will wait the order to catch up with the file. Anything else on docket 22-03199, Mr. Zappin?
Nothing, Your Honor. We'll get that to you today.
All right, thank you.
Have a good day.
That's all for the record in that file. You're all set, Mr. Zappin.
Thank you.
Sure. So are we ready on Mr. Perry Johnson?
Yes, Your Honor, I believe we are.
All right. So we're on the record in a probation violation in regards to docket 22-00387. Parties have introduced themselves for the record. Mr. Brodowitz, how are we proceeding on the probation violation today?
Yes, Your Honor, at this time, the people would be ready to proceed on the probation violation. So I would leave it to the defense to make any motions or anything they would make.
Mr. Milks?
Thank you, Your Honor. Your Honor, so there's two things here. One, I would like to recognize the fact that this court did dismiss this original probation violation when in another matter, we waived to circuit court. And as part of that, the court did make clear that this probation violation would be dismissed. It obviously was reissued when the probation department tried to bring it back. However, this court has absolute authority. The probation department is essentially a wing of the judiciary. They essentially are your investigators, Your Honor. This court has already dismissed it. Because of that, I would ask that the court dismiss this probation violation as we contemplated last time. That being said, Your Honor, we all know my client is currently in Jackson and that he has matters out there that he is facing, and that it's going to be impossible for him to complete the terms of his probation just because of his current incarceration. By law, he can refuse to continue on probation, and the court can revoke him. I guess in a way, I guess it'd be asking for cobs if this is the way we're going to go, but I'd ask that the court consider credit for time served, revoking from probation, and he would lose that 7694A status by choosing to revoke his probation.
So I have as a part of his probation that, and this is the probation on, let me see, he pled guilty to count 2 domestic assault. And then he was placed on probation on that as of June 8th, which is today's date. He had 54 days in. Is that correct?
I believe there was an updated.
It's roughly.
There was one, the pink sheet.
Yeah.
There should be credit on that.
Yeah, I've got 54 days in on that, on the pink sheet. What do you have? On this days in.
Your Honor, as of 5/23, probation calculated him at 44 days. I cannot math.
So 5/23 is 44 days.
So 44 plus 16 is what I have.
90.
44 plus 16, 60.
Or
Yeah,
60.
I have 60. Yep. Mr. Milks, you
That was
are
all.
not good at, you're
No,
not
I am.
helpful at all. I also have as a recommendation from PG that that credit is time served. Do you have that?
That, I believe that's what was conveyed,
Yes,
Your Honor.
yeah. So if I follow that recommendation, would there be, well, I don't want to,
If the court were, if my client were to ask that the court revoke his probation, if he volunteers to do that, if the court were to consider that, he would do that absolutely today.
all right. I think that's where we're heading. No, I think that's where we're heading. So would that be a plea to the probation violation with the understanding that probation is revoked?
Your Honor, I would ask that the court dismiss the probation violation as we originally had, and that he just ask this court to revoke his probation because it's impossible for him to complete it. And pursuant to case law, he does have that right to refuse probation.
What was the violation?
It was from back in February.
Was it failed to report?
Believe.
As well as I believe there are 2 technical violations as well, of failure to pay fines and costs and a failure to provide or failure to enroll, or no proof, I should say, of enrollment in batterers intervention services.
So
Michael Williams, can you hear me? Mr. Williams?
But then we'll never be out of this.
I need you to join the breakout room with your attorney. I sent you an invite.
Because I think the point, Ray, is that we want to be done.
Let's get Brianna. Right.
If you're talking, I can't hear you. You're muted.
All right. So let's get Brianna here. And then we'll all talk about this in chambers. Please tell me she's available.
Well, she's
Because
not,
she
then we
is.
can't move forward because then we don't have evidence to provide, Your Honor.
Yeah.
Oh, that's correct.
Yes, the people's necessary witness.
Wow, Ms. McCray.
If that's.
We're out here.
That answers that question,
That would
doesn't
be
it?
really nice for, and then guess whose fault it is?
Right. Mr. Goodrich is on the
Breakout room with one of his
Oh,
clients.
okay.
So Mr. Goodrich is back. Mr. Goodrich, are you ready to go on any case?
Yes, I'm ready to go on Garrett, Owens, and Cox.
All right, let's do Owens. And Mr. Owens you just met with him?
Yes.
Oh, all right. All right. So we're on the record in docket 2301-672. People of the state of Michigan versus Philip Owens. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Owens.
And sir, you are Philip Owens?
Yes.
And you can hear me all right, Mr. Owens?
Yes.
All right, this is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have not made an offer on this case, so I would leave it to the defense to see how they wish to proceed after discussing with their client.
Mr. Goodrich?
Yes, Your Honor, at this time, we would just like to leave the matter set for preliminary exam next week.
Okay. We'll leave on for preliminary examination for June 15th at 8:30. So, Mr. Owens, please keep in contact with your attorney, Mr. Goodrich. Your preliminary examination will be on June 15th at 8:30. That'll be a live event, okay, sir? So it'll be live on the 6th floor, all right? Mr. Owens, you still there?
Yeah. Hello?
All right. All right. Yep. We lost you there for a second. So we'll see you on June 15th at 8:30. Anything else for the record? Docket 2301-672, Mr. Brodowitz.
Nothing from the people, Your Honor.
Mr. Goodrich?
Nothing from the defense, Your Honor.
All right, Mr. Owens, thank you for your appearance today. You're all set.
Thank you.
Yeah. He's next anyway.
I don't know how to fix that, Mr. Adams.
All right, so we're on the record in docket 2301-664. That's people of the state of Michigan versus Shane Cox. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Cox.
And sir, you are Shane Michael Cox?
Yes, I have, Your Honor.
All right, and you can hear me all right, Mr. Cox?
Yes, I can, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have extended an offer for the defendant to plead to an added count 3 of maintaining a drug house, an agreement for restitution on any damage to the vehicle in question in this matter. And with that agreement, the people would dismiss counts 1 and 2.
Right. Mr. Goodrich, is that your understanding of the offer and the at this time?
Yes, Your Honor, I did convey that offer to Mr. Cox. He would like to take some time to think about that, so we're just going to leave this matter set for an exam next week.
Okay, so the offer has been conveyed. It's maintaining a drug house is count 3, counts 1 and 2 dismissed are the current offer. And at this time, we're leaving the prelim on for June 15th at 9 a.m. And the offer, of course, is remaining open until June 15th. Is that correct?
Yes, Your Honor.
All right. That's your understanding, Mr. Goodrich?
Yes, Your Honor.
All right, so Mr. Cox, the offer's been made. We've set this for prelim on June 15th at 9 a.m. Please keep in contact with your attorney, Mr. Goodrich, in regards to this case. Anything else for the file on docket 23016664, Mr. Brodowitz?
Nothing from the people.
Mr. Goodrich?
No, Your Honor. Thank you.
All right, Mr. Cox, you're all set. Thank you for your appearance and your patience today.
Welcome, Your Honor.
Man, come on, man.
And then Mr. Williams, you're in the right place. We just have some cases in front of you, okay?
No, I can't hear my lawyer when I was just in there with him. If something was wrong, he went out to go talk to somebody and I disconnected somehow.
All right, Mr. Abbott, is Mr. Williams your client?
Yes, he is, Your Honor.
And if we put you in a breakout room, will you be able to hear each other or not?
We'll see. We did not communicate the last time, but we're doing much better now.
Let's give it another shot. And then now I understand why Nathan was saying I can't help with that, because Nathan can't help with that. Well, at least he doesn't have that IT experience to figure out why audio is not working in that regard, I think. Let's put Mr. Williams and Mr. Abbott in a breakout room to see if it works this time.
Okay.
Garrett Remington as well.
All right. Mr. Goodrich, are you ready on Mr. Garrett?
Yes.
All right. So we're on the record in docket 23-01434. That is the people of the state of Michigan versus James Arthur Lee Garrett. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Garrett.
And sir, you are James Garrett?
Yes, sir.
And you can hear me all right, Mr. Garrett?
Yes, sir.
All right, Mr. Brodowitz, this is the time set for a probable cause conference. How are we proceeding?
Yes, Your Honor. At this time, the people would be seeking to dismiss this case. There was a prior case with Mr. Garrett that I believe was in front of Judge Ward. And as part of the plea agreement in that matter, this matter was supposed to be dismissed. In conversations with the prosecuting attorney who handled that matter, she did motion to dismiss that at that hearing. However, I believe there was a brief period of time, and that hearing fell in this brief period of time between when the prosecutor's office issued the charges and when they were actually entered in by the district court. So this case got entered at that time. So at this time, I said the people would be seeking to dismiss this case in accordance with the plea on the previous case, and I have a nollie pros order signed to that effect.
All right, and Mr. Goodrich, is that your understanding? The case is to be dismissed without prejudice per negotiations on a separate case?
Well, I guess it would be, yes. Yeah, it is being dismissed per plea in the other matter. It's part of.
All right, my understanding, there might have been a snafu in that it was reissued, but the case should be dismissed in regards to the negotiations on the other file.
Yes.
All right. All right. And then, Mr. Goodrich, you've been able to convey or talk to your client about any other charges that may be outstanding?
I will talk to him later today regarding other matters.
All right. All right. So in regards to this, this case is dismissed without prejudice per negotiations on another file. I've signed a nollie pros to that effect. It's dismissed without prejudice, which means that people could reissue if they choose to. But for our purposes, pursuant to the negotiation that's already taken place, your case is dismissed today. All right, Mr. Garrett?
Yes, sir. Thank you.
All right. Make it a priority to speak to Mr. Goodrich this afternoon concerning anything else that's out there. All right, sir?
Yes, sir.
All right. Thank you. That's all for the record in docket 23-01434.
Thank
you. That was Mr. Garrett, right? And then we have Ms.
Your Honor, we haven't heard from Mr. Lake yet, have we?
No, how about Mr. Remington, Mr. Goodrich?
She is in the back of court.
She was in the courtroom. I do not know where she is.
All right.
That
She
is-
was in the back of the courtroom.
Your Honor, that case is a situation where I recognized yesterday that her and Mr. Cox are considered co-defendants on the matter, and that I cannot represent both of them. So my office is sending her case to conflict counsel.
All right, Miss Remington, are you Miss Remington? Why don't you come up here and we can place that on the record? So we're on the record in docket 23-01663. That's people of the state of Michigan versus Ramey Danielle Remington. Will the parties please introduce themselves to the record?
Jeff Bartowitz on behalf of the people, Your Honor.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Remington at this hearing only.
Okay, and ma'am, you are Ramey Danielle Remington, is that correct?
Yes, sir.
All right, this is the time set for a probable cause conference. And I understand there may be some conflict issues. So Mr. Brodowitz, what is your understanding? And we can let Mr. Goodrich explain if he needs to.
Yes, Your Honor, it is the people's understanding that Mr. Goodrich is assigned as counsel on a prior matter in front of this court, which would be case 23-01664, People versus Shane Cox, in which Ms. Remington and Mr. Cox are considered co-defendants, and so that the Public Defender's Office is going to have to withdraw and seek conflict counsel in this matter.
Is that your understanding, Mr. Goodrich?
Yes, Your Honor, that is accurate. My office began that process yesterday, but as of right now, I don't believe she has been assigned new counsel.
All right, and so Ms. Remington, you understand that the Public Defender's Office is conflicted out because of a co-defendant, and so we're going to have to get you assigned a conflict counsel or another lawyer in this offense. Do you understand that, ma'am?
Yes.
All right. So I find good cause to adjourn it. It's not your fault, okay? But I find good cause to adjourn the matter. And we'll reset. When is Mr. Cox set for?
We left his on, so we leave hers on. Until
Okay.
we get it resolved next week.
Yeah, so we'll leave it on for prelim for next week with the understanding that hopefully in a week, at least get a name of conflict counsel so they can file an appearance. All right, Mr. Goodrich?
Yes, Your Honor, we will do that.
All right, so I'm gonna leave it on for June 15th at 9 a.m. So Ms. Remington, be present next week at 9 a.m. And you may be contacted by your lawyer, your new lawyer in regard. If not, we'll have a lawyer here and we won't go through this without any representation in order to have any rights protected. But I find right now, we're just going to leave it on for prelim, okay? All right. Anything else for the record, docket 23-01663, Mr. Brodowitz?
Nothing from the people, Your Honor.
Anything else, Mr. Goodrich?
No, Your Honor, thank you.
As generally conflict counsel reaches out to Ms. Remington, is that my understanding?
Yes, they will do that.
All right. So the conflict counsel should reach out to you. If you don't hear anything, show up on June 15th, okay?
Okay.
All right. That's all for the record in 23-01663.
Thank you, Your Honor.
And then, did you want to put Lake and Williams on?
I believe Williams is Mr. Abbott's case. Lake, I would like to make an effort to try to contact him because I've been in contact with him this week, and I'll see if I can
All right,
track him down.
go ahead and go ahead and see if you can and we'll put Mr. Abbott's client on. So we're on the record in docket 22-00388. That is people of the state of Michigan versus Michael Williams. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Michael Williams. We both appear on video this morning.
All right. And sir, you are Michael Williams?
Yes, sir.
Okay, you can hear me all right, Mr. Williams?
Yes, I can.
All right. This is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this time, the people have made an offer to the defense for the defendant to plead to count 2, felon in possession. And with that plea, the people would dismiss counts 1 and 3. I have not had a chance to speak with Mr. Abbott since he spoke with his client, so I would leave it to the defense to see how we're proceeding.
All right, Mr. Abbott, your response?
We're going to leave this on for the preliminary exam, please, Your Honor.
All right. So we'll leave on for the preliminary examination on June 15th at 10 a.m. I'm assuming that the offer remains open?
Yes,
at this time? All right. So the offer remains open. We'll leave it on for preliminary examination for October 15th at 10 a.m. Mr. Williams, please keep in contact with your attorney, Mr. Abbott. You're set for preliminary examination on June 15th at 10 a.m. next week. All right, sir?
You said 10 a.m.
Yep, June 15th at 10 a.m.
Oh, okay. No, it said 9:30. All right, okay.
I have, June 15th at 10 a.m. Anything else for the record, docket 22-00388, Mr. Brodowitz?
Nothing from the people. Your
Mr.
Honor.
Abbott?
Nothing. Thank you, Your Honor.
All right, Mr. Williams, you're all set. Thank you for your appearance today.
Thank you, sir.
Let's go back in chambers on Alton. Perry Johnson.
Yes.
Yeah. Oh, yeah. Come on.